welcome to Legally Speaking with me, Tarun Nangia. Today we discuss the interesting issue of bails in case the trial is delayed. Many times in this country we see that the trial doesn't begin sometimes after many, many months. In that case, should an accused be kept in jail without even being convicted? That is something that we're going to discuss today. And it's an important issue that concerns a lot of promoters, businessmen who sometimes, due to transactions or the other, get involved in cases. But if they are in jail, then how these businesses will be run? Employees are dependent, bank loans have to be paid. So it's a very complex issue. It is not a simple issue of keeping one person in jail because he's suspected to be involved in a crime. And that's why we discuss this issue today with the help of a few court orders and bails that have been given, which my panelists will speak about. Let me introduce you to my panelist today. Advocate Tarannum Cheema joins us. She's a well-known lawyer. He appears in cases of white-collar crimes and also represents the CBI in some cases. But the criminal law side and white-collar crime is an area that she works a lot in. Good to see you, Tarannum, and looking forward to some interesting inputs from you. I have with me Advocate Niharika Karanjawala Misra. She is Principal Associate with Karanjawala and Company and tackles a lot of such cases. Good to see you, Niharika, and looking forward to your insights. I have with me Advocate Archit Singh. He is a partner with Circle of Counsels, a law firm that specializes in areas of white-collar crime, financial crimes, and also they also do a lot of work in SFIO cases also recently, and so on and so forth. Good to see you, Archit, and looking forward to some anecdotes from your end as well. At the outset, let me request Tarannum that she give a longish opening comment, and then we move on to the panelists. Over to you, Tarannum, for your comment.
Hi, Tarun. Hi, Niharika. Hi, Archit. When we first discussed that we are going to be talking on the issue, you had asked me about this judgment of the Punjab and Haryana High Court, which had come out in 2015, called Dileep Singh Maan and another versus Directorate of Enforcement. It was a very important judgment on bail, but unfortunately, it wasn't highlighted that much. And I feel it was the first judgment which actually said that Section 45 and the conditions which are there in Section 45 PMLA would only be attracted when considering the bail plea of an accused who's arrested under 19. So in essence, saying that if the powers under 19 have not been invoked by the Enforcement Directorate, the rigors of Section 45 would not come into play. Now, this was also followed in a couple of judgments by the Punjab and Haryana High Court. And what this meant for the ED was what court on its own motion from the erstwhile Delhi High Court means for the CBI. That if you have chosen to not arrest an accused and you have chosen to file the charge sheet or a complaint without arrest, then upon appearance, you cannot ask for custody of that person. And, court on its own motion by Justice J.D. Kapoor was a guideline which was followed in Delhi, throughout the trial courts. And in 2015, the bench of Justice Suryakant, who was then heading the DB in Punjab and Haryana High Court, along with Justice Bejantri, had given this judgment in ED. And it's a very simple judgment which says, there's another aspect which it covers. It covers the aspect of attachment happening in ED, which also becomes a deterrent to arrest. So it just in one line says that the assets of the petitioner had been, already attached. So that would also count as a deterrent to arrest. Now, in most of the cases of ED, and Archit would obviously guide us when it is his turn to speak, attachment is the first process that happens. Section 5 is invoked as soon after, I would say, the ECIR is sort of registered and any investigation takes place. So Justice Suryakant makes it very clear that your assets have already been attached. You have not been arrested. So to even for the ED to argue that rigors of 45 should come into play, it's not their place at all. And I would say this would go a step further, in bail jurisprudence emerging in ED cases, that once powers under 5 have been used by the ED, confirmation has happened. In essence, what you're looking at, the laundering aspect, you've already covered that. So if something is not compelling, which warrants arrest should happen in rarest of rare cases. And given the stringent conditions, it's become almost impossible to, defend an accused once the accused is arrested. The Constitution bench of Gurbaksh Singh Sibia back in 1980s had said that the purpose of bail is that the accused is in a better position to defend himself. These are matters which are financial in nature. Largely, the kind of evidence is documentary. So the first thing ED does is seize. So they've seized all your documents. They've already sort of attached your properties. So arrest is only there if something is extremely compelling. And what we are seeing is that it is done as a matter of routine now. So I think this is a very, very important judgment. And now, of course, Justice Oak and Justice Bhoyan have also followed this view in Tarseem Lal, and they have said that, but they've just added one rider saying that after cognizance is taken under foot. So that becomes a bit tricky, because after cognizance, and Archit will again guide us, there are cases where ED keeps filing complaints after complaint after complaint, and they keep on delaying cognizance. So that might be, something they can use to their advantage. But Dalip Singh Maan is very, very clear. It says that once Section 45 rigors are not attracted if you haven't used your powers under 90. And it's a very simple, I think, I'm a little bit biased because it comes from my parent High Court, Punjab and Haryana High Court, though we have Justice Suryakant here now, but I'm very biased on this judgment because it's a very simply worded 3-page order which lays down the law, which is how bail orders are supposed to read. So that is my opening comment.
Thank you, Tarannum, for this opening comment and explaining your perspective in detail. Going to Niharika Karanjawala from Karanjawala and Company for her opening comment.
Yes, sir. I couldn't agree more with Tarannum, and I think she took us through the precedent on it beautifully. And as such, I would just like to focus on the practical aspect of it for a second, since that hasn't yet been gone into. As Tarannum said, Sibia clearly laid out that one of the main purposes of bail is to allow an accused the liberty and the freedom to properly defend their case. And from a practical perspective, that is what we want. We don't want a scenario where hurdles are repeatedly placed in the defense of one's case. We saw, I don't think anything could have denoted it more clearly than the period through COVID right now, where it was practically impossible to meet your clients who were jailed face to face, where you were doing everything over VC, where you couldn't really speak with them freely. This sort of liberty is required, and it's really, really gratifying in every instance to see the courts moving towards a liberty perspective. The Dalip Singh Maan judgment, I completely agree, is very, very significant from this perspective. Let's look at it from the perspective of the system as a whole. The system as opposed to just the individual who is being granted bail. The system is also one under a tremendous amount of pressure. There's a huge overcrowding of jails, and where it is not required. If you look at some of the other states as well, states like UP, things like that, very often people who don't have adequate legal representation, they have more than lived out the maximum sentence they could ever have faced while being under trial. Their cases are nowhere close to being heard. They're in cold storage and they're simply living their lives in jail. They have a job, they are part of the system, and it's going on that way. They are not aware of what's happening with their case or whether it continued or whether they were convicted or what happened. So from a practical perspective also, we need to see it from both the view of the system as well as the view of the individual. And from both the view of the system and the individual, this is an extremely beneficial measure. Also from the perspective, as you said, there is this notion in businesses that once you get drawn into it, it's a never-ending process. As Taranam said, cognizance is put off. There's this great fear associated with businesses and things like this, of ED cases, of the PMLA, of the Enforcement Directorate taking steps against you. And there's this general notion that then liberty will not be granted to you and you will live the rest of your life behind bars. But cases like this, judgments like this, give people confidence, give investors confidence from the perspective that there is not arbitrariness in the system. And I think that is what people want to see. And that is what the Mann judgment, as Taranam said, lays down very clearly. In a simple 3 pages, it clearly lays down the law and it removes a lot of the arbitrariness. So that is what I was really happy to see.
Thank you, Niharika, for your opening comment. We will now go to Advocate Archit Singh from Circle of Counsels for his opening comment. Over to you, Archit.
Hi, Tarun. Hi, Niharika. Hi, Tarun, ma'am. How are you? Thank you for having me on the show. And just to start off, I think my co-panelists have really laid down the groundwork and, brought in a very essential judgment that we've been discussing about recently. I think Tarun ma'am also mentioned Dileep Singh Mann is an old judgment, but it is a judgment which has an impact which we're still facing today. Now, it's a less known judgment, perhaps, which is why it's not highlighted. It's okay. But the considerations in this judgment are very important. There are 2 very important facets, as ma'am described, that this judgment goes into. First, naturally talks about an intrinsic link between section 19 and 45. Naturally, if an agency is not arresting you on the basis of guilt, I cannot be portrayed or forced to argue my bail on the basis of whether I'm guilty or not. So definitely that intrinsic link that this judgment draws is very important and very relevant because it's an agency's choice. They decided to arrest me under the CRPC. There are consequences there too as well. Second important thing that the judgment also points out is regarding, and it has a direct link to section 436A of the CRPC, which is when half a sentence is gone. Now, over here, even in this order, the judgment, although, the court doesn't really go into 436A or doesn't specifically write it, one of the points it does discuss is the maximum sentence over here is 7 years. So effectively, once a person has undergone, say, 3.5 years or 3.5 years, you ought to be granted bail. And consider this, Tarun. This is bail granted to a person who is still under trial. That means there is no determination of guilt by a court of law of this person. 3.5 years is not a small time. Try spending jail for 5 days. I'm telling you, you won't be able to do it. So what is the consideration? As we've been discussing today, what is the purpose of a bail and what is the purpose of putting a person behind jail? The intrinsic value lies over here. And I think, of course, we're talking a lot about the economic offenses over here today. There is a line that has been, I would not even use the word blurred. I think it has been shattered where presumption of innocence has gone out the window. I cannot be asked to talk about guilt prior to even conducting a trial. The ball is not in my favor. The ball is always in an agency's favor. And mind it, saying no matter how rich a person is, the government power is always greater. The state's power are always greater. 2, as I think Tarun ma'am rightly pointed out, once you've attached a person's assets, you virtually handicap them. So if you've handicapped a person, so if you go and say this person's such a big businessman, they can influence the witnesses. How? You've seized all my assets. What am I left with? But the ability to defend myself. That too you don't want me to do because you want me to stay behind bars. But coming to the main focus, which is the delay that the way the agencies and the system is causing. The way the system is working, we have charges that are filed upon the 60th day, ensuring that a person doesn't get the benefit of what we call the default bail, right? That is, once a certain amount of period has passed, a person is entitled to bail by the process of law not being followed, or, by the process of law, ensuring that I'm not supposed to be. There was an intent behind the provision that a person should not be incarcerated or kept behind bars indefinitely. Now that is being turned on its head by saying, I have enough evidence against this person, but the case as a whole, I still need to prove. So there's some more things I need to get. Charges are framed? No. Case is going on? No. Trial has begun? No. I want him behind bars. There needs to be some form of a intrinsic boundary that we have to draw. And the inordinate delay in these trials only affects one party. It never affects the state. In fact, it is only to the benefit of the state. So I think that is where I would like to end my opening comment, and over to you, Tarun.
Thank you, Archit, for your opening comment on this issue. I'll take this to Advocate Taranum Cheema. I would like to know these two things from you. More often than not, we have seen that businessmen spend over a year, maybe more, in jail before the trial has even begun. And sort of the companies that they run into trouble because, the promoter is in jail. Secondly, bank loans get stuck because, when the promoter is in jail, bank loans go for a toss. Banks suffer, employees lose their jobs. It's a difficult situation overall. Do you think, given that in mind, the view taken by Justice Suryakant and the courts, do you think we could see better days ahead where if a person's evidence against a person is documentary, then you don't keep him in jail? If he's convicted, then he sure will go to jail. But don't keep him for jail for 3.5 years and then bail him out. By that time, everything is a lot of water has flown down the river, and the banks gain nothing, the companies goes bankrupt, and nobody benefits. And the person himself becomes dejected, having spent half of the term if he were to be convicted in jail. Since this is a living reality for many people, because prosecutions have gone up in the recent years for bank frauds and financial crimes, could you explain this in that aspect?
Absolutely, Tarun. It's a very pertinent observation that you make with regard to, businessmen spending a lot of time in jail and the trial not even commencing, so to say. And this has been the trend in the recent past. Actually, it started when the 2G trial first started in this country. That was one place where court on its own motions judgment was given a go by, and some of the businessmen who had appeared after summons were sent to jail. And I'm sure Niharika would second me on this, because she was also representing a set of clients there. And we were all in shock because that had not happened in Delhi for a very long time. And that then took the judgment of Sanjay Chandra versus CBI from the Supreme Court to again resettle the law, saying that, this is arbitrary. You can't do that. You can't keep a person behind bars indefinitely till the trial starts. And also, we have to be very mindful of the fact that most of these cases will not start because they will never say that the investigation is complete, be it the ED, be it the CBI. The first charge sheet they'll file is a very, very presumptive sort of a document. The real investigation keeps going on, and supplementary charge sheets or supplementary complaints keep coming. And once that happens, as a defense lawyer, I wouldn't want to argue on charge, because I may then end up giving out my defenses and the agency might then go and improve their case. So I have to be very, very sure about what the agency is alleging against me before I can start my argument on charge. And that would have the effect of my client spending substantial amount of time in jail before being, before there being an actual charge against him. So we all need to relook into that. And Dilip Singh Maan actually, the important observations that it makes with regard to the period undergone, with regard to the assets already been attached, with regard to rigors of 45 when applicable, it ensures that, end of the day, what you're looking at is a fair trial. We are not there to not do a trial. We're not there to prolong a trial. Defense lawyers always want to go ahead with the trial, but we cannot open our defenses till the investigation is complete. And now you've seen in bigger matters, for example, the liquor policy, etc., the investigation is just never ending. And in that aspect, when you're looking at the economy, you're looking at bank frauds, you're looking at what it's doing to the system, or let's just say in an ED matter, suppose they've taken over my assets, there's nothing I can do. They will eventually want to, attach everything. I keep fighting. In ED, you're fighting actually on two levels. You're fighting a civil litigation before the adjudicating authority and the tribunal, and then subsequently the High Court. And then you're fighting a criminal litigation where you're looking at personal liberties, etc. So you are just wound up in so much litigation in these matters. I mean, at some point, we have to see what was the object of these acts. The object of the ED Act was essentially to bring the system clean of drug trafficking money, those, or terrorism, etc. Those were the objects of the act. Today, it's been used to stifle businesses in the country. And we have to, at some point, start following these judgments. This judgment has been out. It's dated 1st October 2015. But how many trial courts have followed this? So over to you, Tarun.
Very, very relevant points made. And, you made that statement in between that how do you open your defenses when the agency is saying that its investigation is not complete. It completely goes against the grain of how do you defend your client when the agency is not saying its final word. You can't begin defending your client because the agency may again come up with something, and there is no finality to the investigation. And it is a nightmare for a defense lawyer in that case. Less said about the accused, who would have spent 2 years, 3 years in the jail by then. I'll go to Niharika Karanjawala at this point for her comment on the same issue of do you think the courts will start looking at these cases pragmatically, and we will see bail as a rule approach soon enough? Of course, the courts have been reiterating, and with judgments like Dilip Singh Man, the courts have shown their intent. And we are lucky that somebody who's pro-liberty in the form of Justice Suryakant is now in the Supreme Court. So those principles, of course, remain, because he is now at a place where, of course, his decisions could influence in the positive sense, a message to all the other courts in the country, the high courts and the district courts. Over to you, Niharika.
I do think so, Tarun. I am very, very hopeful because we see a lot of fear associated in our clients with these agencies that are they are extremely powerful agencies. They have a tremendous amount of talent, a tremendous amount of investigative talent, but a tremendous amount of power, perhaps too much for one agency to wield on its own. And from that perspective, it's very important and very, very, it inspires hope to see that the courts hold a staunch liberty-oriented outlook to it. As Saranam brought up, one of the very clear practical problems is how do you defend yourself against a case that has not been put forward to you yet? And how am I opening up my defense at a time when it could just be going towards helping the prosecution finagle their case against me with a little more finesse and put it forward in a slightly different way and make it clear that, oh no, but I mean, she didn't cover any of these points, so that's it. So these are all practical aspects that need to be looked at very depthfully. I am very hopeful that the courts are moving forward in a very good way in this measure. You see very good judgments like Dalip Singh, you see Vijay Madan Lal. They all have an underlying toe towards individual liberties. And this, especially from the perspective of a defense lawyer, is something that's very, very hopeful to see. We have our clients outrightly afraid from the beginning when a police case starts, when a CBI case starts. One of the big fears everyone has is, could the ED get involved? Could a PMLA accusation be made? Could something like that happen? And in a lot of white-collar crime, it's almost a foregone conclusion that, yeah, they will get involved. And like Tarana ma'am said, this is not necessarily the intent with which these acts were put forward. So I am very hopeful, and I feel that the courts are moving towards a liberty-oriented view. Yes, it would. I mean, would it be great from the perspective of a defense lawyer to see it moving a little faster towards that and to see these judgments being followed more in the letter and spirit? Yeah, certainly it would be. Certainly it would be.
Point well taken, Niharika. I'll take this to Advocate Archit Singh from Circle of Counsellors. Over to you, Archit.
Tarun, just to start with, I think there's a very important fact that has been brought on over here, and which is about how do you start defending a client when you don't know what the agency even wants to prosecute you about, right? You may have you have the start point, but you don't know where it's ending. And I've had a little brush of my own, working on the prosecutorial side of things. And, we used to wait. Let them file the bail application. We'll find out where our case is weak. We'll cover it up. So it is actually something I know, as a matter of fact, the agencies are looking forward. Let's arrest them. They'll file their bail. We'll know where our case is weak because they'll give everything under the sun. This is where the agency is not covered. That is what they've not covered. And the prosecution agents are very happy. Like, fantastic. We now know where we lack. And with power of filing supplementary charge sheets, they're like, okay, fine. I didn't cover this in the first one. Thoda aur kar lete hain. We'll take it a step forward. No worries. Why? Because we know the guy is not getting a bail. We know the bail is not going to happen. We don't need to put much effort into it right now. We'll see when the right time comes. Because calling something on a prima facie guilt, I think this is the first time, there are very few acts which have this concept called prima facie guilt. You'll only find them in some of the most stringent acts. Even in NDPS acts, it is only applicable in commercial quantity, mind it. When you're dealing with smuggling, when you're dealing with organized crime, you're not dealing with it, you're a businessman and you're like, first let him prove his guilt. What is prima facie guilt? Whose evidence is to be considered? Is all evidence to be considered? Are the agencies today ethical enough to even bring, like, there are so many cases, Tarun, where I've seen we give representations to the agencies and that is not brought on record. And the argument is simple. I've not even filed my charge sheet. I'll bring it in then. But before that, I'm not obliged to. And this is a systematic failure on a criminal justice system. This is very problematic. And I think this needs to be seen from that angle and perspective when you're seeing how this leads to a delay in a person's trial, how a person is spending their time behind bars. And I think how you also pointed out the fact that how this affects businesses in a whole. As a whole, the businesses are no longer able to function. See, India, we have a lot of promoter-driven businesses. It is often a one-man show, right? A person who is running the entire thing, or at least has the most intricate knowledge of what has happened. Now, if this person is behind bar, lawyers are unable to meet him at all points of time. There are so many restrictions in place. Second, how freely can I talk? There is a reason why you have attorney-client privilege. But if I'm sitting in jail, can I really talk freely to my advocate now? No, I can't. So, yes, I am being denied a fair trial at that point, which I'm entitled to under law.
Point well taken, Archit. Thanks for explaining those points. Now, in about 30 seconds each, we'll take closing comments to this show. My question for the closing comment largely being, see, investors all over the world are watching whenever a businessman's bail is delayed, because it is in the nature of business to track each country. And based on that, they invest in a particular country. It's a business decision. When they see that bails are not easy to come by, the investments may get impacted to some degree because of a general fear. Generally, it is seen that capital will flow to countries where the liberty standards are high, and capital will withdraw where the liberty standards are not that high. India needs a lot of foreign capital to grow. Given that as a concern, do you think the courts pushing this libertarian agenda will help investments? It's not the court's job to promote investments, that is what we understand. But what the courts invariably do impacts. So, it is still a cause and effect relationship, sort of, that somebody remaining in jail for 4 years may put 10, 15 promoters away from investing in a country that, this is too risky, those kind of things. Very quickly, closing comments from all the three panelists. Over to you, Tarannum, for your closing comments.
Again, a very pertinent point you make, Tarun, regarding the investors coming to India. When I had earlier referred to Gurbakht Singh's CBI in the 80s, now one of the opening lines of the judgment was that as long back as in 1924, when those sedition trials were going on and the emperor was ruling India. From that point on, India's jurisprudence on bail has been that bail is the rule and jail is an exception. And that's what Gurbaksh Singh Sibia in the 80s took forward. And we've been very, very liberal. Our courts had been very, very liberal with bails until these twin conditions came. Of course, then we had the Nikesh Tarachand era and the post Nikesh Tarachand era. I mean, I wouldn't want to comment on that. But, when you're looking at ED cases, you're seeing a trend of just sort of encapsulating in investigation any and every business house. I'm sure Niharika and Archit would also, sometimes the lawyers come and say, oh, it's a very good thing for lawyers because ED keeps them very busy these days. But the thing is that for the businesses and for the country's economy, it's not going to be a good thing, because how can a business function under the fear of being prosecuted by an agency? And it's very, very systematic, stepwise, encroachment on their rights, which starts from giving successive summons to appear, and it's absolutely the investigating officer's discretion. He can cut out whether the person can appear through an authorized representative. And then comes the attachment, and then comes the fear of bail. So it's very, very draconian in that sense. And I think we need a relook into all of this. And especially the courts need to follow precedent and at least on bail, be very, very sure. Because once all these things have happened, the person is not going to flee. And that those judgments, and if you feel that the person is not a flee risk, then let him defend his case and let the trial go on. Because ultimately, the investors are going to see that what we are doing, and they will. And I've also had cases where some of the investors are sent these summons, and the summons, I would say, are very, very loosely worded. They are asking for each and everything. So, you don't want to give out that information. It's like always in a nature of a fishing and roving inquiry, I would say. And nobody wants to give out that information because you don't know how it's going to be used, whether it's going to be used by competitors, where it's going to be used. So we need to take a cue from the judgment that we've discussed. And also we need to be hopeful that courts will look at this and find a solution. Because as happy as we are with a lot of work coming our way, because ED is extremely active, we also must think of the larger perspectives governing the country. Thank you, Tarun.
Point well taken. Thank you, Tarunum. Closing comment from Niharika Karajan.
Tarun, as I've said before on this topic, I feel that the opposite of and the enemy of investor confidence is arbitrariness and the notion that the agencies will act in an unfair manner and the courts will not be able to come to the individual's rescue and not be able to come to the individual's aid. And from that perspective, I think that judgments of this sort are taking us forward considerably in investor confidence. I hope to see a lot more judgments of this sort, which will go further. As Tarun said, it is not the right thing for businesses. It is not the right thing for the economy, and it is not the right thing for the individual, for liberty to not be the primary concern. And from that perspective, I hope to see much more of this going forward.
Point well taken. I'll go to Advocate Archit Singh for his closing comment.
So, Tarun, I think I agree with both my panelists. They've been very fair in saying that, yes, there is an impact on business houses. There's an impact on investors because, see, at the end of the day, a foreign investor is here to make money. They're not here to make our lives better. They're not here for other things. They're here to make money. But if in a domain, now there are two things to this. Procedure is supposed to provide you a way forward, not arbitrariness. Now, if a procedure is set in stone and followed through and through, the problem is every day you get a judgment converts to it in 2 days. So it's very hard. A lot of times the clients do come, they do ask like, okay, this is a problem we're facing. Where are we heading? And there is no one way you can tell them. You have to tell them, okay, this is what we anticipate, but also this is possible. So that does create a lot of complexities at times. I know a lot of businesses which were doing well before the case. The cases are going on, but the investors wait. They're like, okay, you know what? Okay, even if a quashing is going on right now, okay, fine, we'll wait. Let it be quashed. Then we'll invest. Right. So this has led many times. In fact, startups have been failing in the recent past a lot because of such actions. There are startups which went big and then they started going down because suddenly an IT raid comes, followed by ED raid, followed by XYZ, and the investors suddenly feel underconfident. They want to know what is the perceived outcome. Now when a person is then arrested, see, always remember, arrest in this country is always associated with guilt. So when you arrest a person and the perception, now here's the thing, I have a right to defend myself, but what is the market perception that goes? This person's perhaps guilty. Maybe there are no touch zone. Let's avoid these people for now. Later if they prove themselves, we'll go to them, but not right now. Let's find alternatives. It has a massive damaging impact on the economy and on individuals, especially. It doesn't impact large business houses as much as it has an impact on small and medium enterprises. I think that's where.
Thank you for that input, Archit. Mainly the last point where you said that the medium and small businesses will tend to be in much bigger trouble. Maybe the big guys can bear it out with a lot of a battery of lawyers and also financial muscle. It was very interesting show today where we veered into various aspects of the libertarian approach by our courts. Also, what is the way forward? Maybe I'd like to take this conversation forward with the panel in the next show, where we could discuss a few other judgments. This time we focused on Dilip Singh Man versus Enforcement Directorate, authored by Justice Suryakant. But this is an ongoing issue, and also we have the 3 new laws into force. We have to see how they play out. Everybody is curious because even the investigators say that it's a new thing for them, because even they have to, it's not easy for even the agencies. They have to read the new laws, not the lawyers. Of course, it's another nightmare to reread everything again. But we will come back to that. I appreciate that Advocate Taranum Chima, Advocate Niharika Karanjawala from Karanjawala and Company, Advocate Archit Singh from Circle of Counsels. You all could make time and join us. And viewers, thank you for appreciating and joining us. Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.